federal government's most powerful weapon just broke. Not a missile, not a satellite, not a budget line buried in some classified ledger nobody reads. A legal weapon, a courtroom weapon. The single most aggressive tool Washington has used for 50 years to override the states, to crush local laws, to hijack policy decisions that were never supposed to be theirs in the first place. And in 163 emergency ruling, the Supreme Court just snapped it in half. The Supreme Court's new 6-3 ruling shocked everyone, not because it was unexpected legally, but because it finally said out loud what millions of Americans have been screaming about for years: Washington has been governing by injunction. Federal judges have been writing national policy from rooms most citizens couldn't find on a map, and as of this week, that game is over. So sit down, pay attention, because what just happened in that courtroom is going to reshape how your country is run for the next 20 years. I want to ask you something before we go deeper, and I'm not going to insult your intelligence by begging. If you're still here, if you're still reading, if you're still angry that nobody on cable news is explaining this in plain English, then you're exactly the kind of person this channel was built for. Hit subscribe, drop a comment with the word broken, so I know you're tracking with me, because the algorithm only pushes this kind of reporting to people who interact. Cable news has billion-dollar budgets. We have you. That's it. So if you want this kind of journalism to keep reaching people who deserve the truth, the cost of admission is one click. Now let's get into it. You've heard of executive orders. You've heard of acts of Congress. You've heard of Supreme Court decisions. But there's a fourth weapon, and it's the one Washington has quietly used to control your life more than the other three combined. It's called the nationwide injunction, and until this week, almost nobody outside of a law school knew what it was. Here's how it worked. A single federal judge appointed for life, accountable to nobody, and a courthouse in some city you've never visited could issue an order that froze a state law across all 50 states. Not just for the people who filed the lawsuit, not just for the state where the court sits. Everyone, everywhere, with one signature. Texas passes a border law, a judge in California can freeze it. Florida passes an election rule, a judge in Hawaii can shut it down. That's not democracy. That's not federalism. That's not even constitutional law as the founders understood it. That's monarchy by gavel. And here's the part that should make every American, left, right, libertarian, independent, absolutely furious. Both parties have been using this weapon for decades. When Republicans couldn't pass policy through Congress, they ran to friendly judges in Texas. When Democrats couldn't pass policy through Congress, they ran to friendly judges in California. The result? You, the voter, got cut out of your own government. Your elected representatives became background noise. The real laws of this country were being written by unelected judges in chambers most of you have never heard of. And the press. The press let it happen because the press benefits from the chaos. Every nationwide injunction means another breaking news cycle, another panel of experts, another segment to fill. But while they were chasing ratings, your sovereignty as a citizen was quietly being dismantled. That weapon just broke, and the people who profited from it are not happy. Late one night, with almost no warning, the Supreme Court issued an emergency order in a 6-3 vote. 6 justices on one side, 3 on the other. No oral arguments, no months of briefings, no leaks to the press, just a ruling fast, hard, and final. The case itself started weeks earlier when multiple states sued the federal government over what they called blatant overreach. They argued that federal agencies, hiding behind emergency orders and bureaucratic regulations, were effectively rewriting state laws without any vote, any debate, or any congressional approval. The lower courts responded predictably by granting the kind of quite sweeping nationwide injunctions that have become routine. And the Supreme Court looked at that and said, no more. The majority opinion was crystal clear. Lower courts do not have the authority to freeze laws affecting millions of people when the actual lawsuit only involves a handful of plaintiffs. If you sue, you get relief for yourself. You don't get relief for the entire continent. That's how civil law has worked for centuries. Somewhere along the way, federal judges decided they were emperors. The Supreme Court just reminded them they are not. Justice Gorsuch wrote a concurring opinion that should be carved into stone outside every federal courthouse in America. He said injunctions must go only as far as necessary to protect the actual plaintiffs, not to rewrite the rules for the whole country. And then he dropped the line that hit Washington like a hammer. He said federal judges must stop acting like mini legislators. Mini legislators, read that twice. The second most senior conservative justice on the Supreme Court just publicly accused America's federal judiciary of pretending to be Congress, because that's exactly what they've been doing. And the emergency nature of this ruling, no full hearing, no slow walk through the appellate system, tells you how serious the justices were. They didn't want to wait. They wanted to stop the bleeding. Now here is where the hypocrisy gets thick enough to choke on. Within hours of the ruling, state officials were celebrating openly. They called it a historic victory for federalism, for self-governance, for the basic constitutional idea that states are not branch offices of Washington, but behind closed doors inside the Department of Justice. The language was very different. Officials there were describing the ruling privately as a legal earthquake. Those are their words, not mine. Earthquake. And the White House released one of those carefully worded, lawyered-up statements that says nothing while signaling everything. They said they were reviewing the court's order. Translation, they are panicking. They know that the legal shortcut both political parties have relied on for decades just got shut down, and now their entire litigation strategy needs to be rebuilt from scratch. So let me ask you something. If this ruling was simply about legal procedure, why is the DOJ calling it an earthquake? If this ruling was just a minor technical adjustment, why is the White House refusing to comment in plain English? Because they know what you and I are now figuring out. This wasn't a technicality. This was a power transfer. And the people who lost power don't want you to understand what just happened. Quick break, because I know some of you are still on the fence about subscribing. Look, I get it. Your inbox is full. Your feed is noisy. Everyone wants your attention. But here's the deal. I'm not selling you a course. I'm not pushing a supplement. I'm not running a political party. I'm reading actual court rulings, actual press releases, actual congressional records, and telling you what they mean. If that has any value to you at all, hit subscribe. Drop a comment with what you think happens to the DOJ next, because the algorithm watches engagement, and engagement is the only thing keeping independent journalism alive in 2026. Now back to it. So let's get practical. Who actually wins from this ruling and who actually loses? The winners are the states, every governor, every state attorney general, every state legislature that has been fighting against federal overreach just got handed a sword. If a state passes a border enforcement law tomorrow, a single judge in another state can no longer freeze it nationwide. If a state passes a firearms law, an election integrity law, an environmental regulation, whatever your politics, the federal government can no longer shop around for a friendly courtroom and shut it down everywhere. That's a massive shift. The losers are the federal agencies, the Department of Justice, the EPA, the Department of Homeland Security, the Department of Education, all the agencies that have grown comfortable using federal litigation as a backdoor to overrule state laws. They just lost their easiest tool. From now on, if they want to block a state policy, they have to win it the hard way, through Congress, through legislation, through the messy, slow, accountable process of actually convincing the American people. And the dissent Justice Sotomayor and the two other dissenting justices warned that this could create chaos. Some states will enforce a law, others won't, and the country could become a patchwork. They're not wrong about the patchwork part, but here's what they missed. America was designed as a patchwork. That's literally the whole point of having states, 50 laboratories of democracy, 50 different experiments. The founders didn't want a single uniform national policy on every issue. They wanted competition between states so that bad ideas could fail locally instead of crushing the entire country. The dissenting justices want comfort. The majority chose the Constitution. And ordinary Americans, you're the real winner here. Because for the first time in a generation, your vote at the state level actually matters again. Your governor matters again, your state legislature matters again, and the federal courts can no longer overrule your community from 1,000 miles away. The cable news shows are pretending this ruling came out of nowhere. It didn't. The Supreme Court has been building toward this for years, ruling after ruling, dropping breadcrumbs that anyone paying attention could follow. Earlier this year, the court ruled in Labrador versus Poe, a case that placed similar limits on the power of lower courts to issue sweeping injunctions. That was the warning shot. This ruling is the canon. And before Labrador, there were other cases, going back almost a decade, where the justices kept pushing back against the idea that a single federal judge could write national policy from a single courtroom. Why didn't you hear about any of this? Because it doesn't fit the cable news formula. It's not a personality fight. It's not a culture war flashpoint. It's a slow, methodical constitutional correction. And slow, methodical constitutional corrections don't get ratings. So the press ignored it. And while they were chasing celebrity scandals and political circus acts, the highest court in the country was quietly rebuilding the wall between the judiciary and the legislature. And now the wall is back up, and the press has to scramble to pretend they saw it coming. Here's the deeper pattern. For decades, both parties have used the federal judiciary as a weapon to avoid the hard work of democracy. Democrats couldn't pass certain immigration policies through Congress, so they ran to judges. Republicans couldn't pass certain election rules through Congress, so they ran to judges. Both parties were guilty. Both parties got addicted, and both parties just got told the buffet is closed. This is what an independent judiciary actually looks like, not a partisan tool, not a rubber stamp, not a backstop for whichever party can't get its agenda passed. A court that says "and" means judges are not policymakers. The Constitution is not optional, and nationwide injunctions are not in the rulebook. If you've ever wondered what separation of powers actually means in practice, this ruling is the textbook answer. Now let's talk about real life, because every legal ruling eventually lands on a kitchen table somewhere, and this one is no exception. If you're a small business owner who has watched federal regulations crush you while your state government tried to protect you, this ruling helps you because your state can now actually pass laws that stick. If you are a parent in a state that has fought the Federal Department of Education over curriculum, testing, or local school policy, this ruling helps you because your state can now enforce its own standards without a judge in another state hitting pause. If you are a gun owner, an immigrant, a voter, a farmer, a worker, pick your issue. This ruling changes the playing field. Your state's law is now more durable than it was a week ago. But, and this is the part I'm not going to soften for you, durability cuts both ways. If you live in a state whose policies you disagree with, you can no longer count on a friendly federal judge to bail you out. The fight has to happen at the state level. Now, at your state house, at your governor's office, at your local school board, at the ballot box. You actually have to show up. You actually have to vote in state elections, the ones nobody pays attention to. You actually have to know who your state representative is. The federal escape hatch just closed. That's terrifying for people who've spent decades outsourcing their politics to faraway judges. And it's empowering for people who've been telling Americans for years that local government is the only government that actually listens. Both reactions are valid, but the new reality is the same for everyone. You want change. You have to earn it the way the Constitution intended, through your neighbors, through your community, through the people you can actually look in the eye. That's not chaos. That's citizenship. Don't get comfortable. This is not the end. The federal government, through the DOJ, through allied advocacy groups, through future test cases, is already preparing to push back. They will look for loopholes. They will look for exceptions where they can argue that the national interest justifies broader relief. They will appeal, refile, reframe, and reword the same arguments in different cases, hoping that somewhere down the line, the Supreme Court softens the ruling. That's the playbook, and the playbook is already in motion, because this was an emergency ruling, not a full written opinion after oral arguments. The door is technically still cracked open. The case will likely move back through the appellate system, and lower courts will now be forced to apply the new, narrower framework. Expect chaos at the appellate level for the next 6 to 12 months as judges try to figure out exactly how narrow really is. But the message from the majority is unmistakable. The Constitution does not allow judges to govern the entire country from a single courtroom. That principle, once stated this clearly by the highest court in the land, becomes very hard to walk back. The next year is going to be wild. You're going to see state attorneys general filing aggressive new lawsuits, knowing the federal government can't shut them down nationwide. You're going to see governors taking bolder positions, knowing their laws will actually survive long enough to be tested. You're going to see Congress, yes, the slow, broken, perpetually gridlocked Congress, finally being forced to do its actual job, because the courts just told the executive branch it can't legislate by lawsuit anymore. And the American people, you're going to have to choose. Are you going to keep treating politics like sports, yelling at the TV while the real decisions get made somewhere else? Or are you going to start paying attention to the elections that actually shape your daily life? The state ones, the local ones, the ones that, after this ruling, just became the most important political battlegrounds in the country. The Supreme Court did its job this week. They handed power back to where the Constitution always said it belonged. The question now is whether the American people are ready to take that power and use it, because if you don't, somebody else will. And we already know how that movie ends. Here's where I leave you. If this video clarified something that cable news refused to explain, you already know what to do. Hit subscribe, drop a comment telling me what state policy in your area you think is going to be the first big test of this ruling. Share this with one person, just one, who keeps complaining that nobody is reporting the real stories anymore. That's how this channel grows. That's how independent journalism survives in 2026. The federal government's most powerful weapon just broke. The Supreme Court's 6-3 ruling shocked everyone, but it shouldn't have. It was a long time coming. And now the question isn't what the court did. The question is what you're going to do with the power they just handed back to you. Don't waste it. I'll see you in the next one.